All right. Hi, everybody. Welcome. We still have a few people joining up. Please come on in. You should all be here for the EU data privacy versus US legal hold webinar, Resolving the Conflict. Hello and welcome. My name is Sandra Serkes, and I am the president of Valora Technologies. As many of you know, Valora creates auto classification technology that analyzes files and documents to determine first what they are and contain, and second, what their proper disposition should be across a suite of legal concerns. There are information governance concerns, such as retention and records policy, as well as litigation needs, and more recently, privacy obligations. In fact, this whole webinar today came about because for those of us in the auto classification business, the various file dispositions often come into conflict with one another. What to do with the file that's past its formal retention but still under legal hold? What about the file that's responsive to litigation claims but contains sensitive PII? Who wins, when, and why? To help us resolve such inherent conflicts, as well as the confusion in general around GDPR and EU legal concerns versus US ones, I've asked some of the brightest minds in the business to share their views with us. David Rohde of Epic and Denise Backhouse of Littler Mendelsohn. I'll let them introduce themselves in just a moment. Just a couple points about the webinar itself. Obviously, you've all been muted, but we do very much appreciate your questions. So please type your questions into the question text bar on your screen, and we will try to get to as many as we can. Just a note on that, this is a discussion only about important legal topics. This is not legal advice and should not be construed as such. We will also be running polls throughout the webinar. Please respond promptly and we will share the results with everyone in real time. Here comes your first one. Okay. There are nearly 75 people attending this webinar right now, and we come from a wide swath geographically, as well as the organizations that we represent. Almost all of you have voted. Thank you so much. And I will share that information in just a second. All right, nearly everyone has voted. And I'll give you a good representation of who is here today. All right, we'll give it another 5 seconds or so. All right. So here's who's here today. A nice wide swath between corporate interests and law firm interests. We didn't ask specifically where in the world you are from, but I know from the registrations, we have a healthy dose from Europe, as well as a larger majority from the United States. But we also have folks coming from Canada, a few here and there from South America. It's pretty exciting to see where everybody's from. All right, we're going to move on into it now. As I said, I'm your moderator, Sandra Serkes. I'm the president and CEO of Valora. We're a leading provider of auto classification technology and solutions for file analysis, such as automated legal hold and sensitive data detection. Denise, would you introduce yourself?
Thanks, Sandy. So I'm a shareholder and e-discovery counsel at Littler Mendelsohn. We're a labor and employment firm, so it's on the defense side, so it's 100% labor and employment law. I counsel people on U.S. litigation, the discovery aspects of U.S. litigation, and specifically I cover cross-border data transfers in the context of litigation, internal investigations, and government investigations. David?
Thank you. I'm David Rohde. I'm Senior Director of Consulting Services for Epic. I grew up as a litigator and moved over to the consulting world and have found my way at the intersection of law, technology, privacy, and the global nature of the businesses with whom I consult.
Okay, so that's who you have here. I'll be serving as the moderator role, and I'm really going to let Denise and David be the experts on these topics. But I'm here to sort of represent the layman's view and to reflect the questions that we get all the time from clients who are trying to navigate all of this. In theory, we have a little bit of the European flavor through Denise and some of the American through David, but they have warned me that is not mutually exclusive and they both cross all boundaries. So you'll hear it straight from their mouths. Okay, this is really what we're going to talk about today. We're going to cover all the different obligations, maybe not exhaustively, but the key ones around these areas, what some of the conflicts are and where they come from, some considerations around why this has happened and what's happened historically, and some takeaway actions for all of you so that you can actually navigate this. We're just going to stop and take another poll. We talked about what organizations are here, and now we'd like to know what your role is in your organization. Again, to get a sense of, are we tilted towards legal, towards IT, maybe information governance, something else? Let us know kind of what you're responsible for, because that will color our conversation a little bit. Definitely legal is pulling to the forefront, not surprisingly. Okay, we'll leave that open for a couple more seconds, but almost everybody has voted and told us what you're responsible for. All right. And here's who you all are. So we got, again, a nice variety, definitely legal influence here and information governance and records. All of you are dealing with these issues, I'm sure, as is IT. So that was pretty much what we expected. So nice to see that that is who's here. You're all in the right place. Okay, so let's move on to the obligations. When this first started out, as I mentioned, it really resulted from my own personal confusion on kind of which argument rules the day. Something like, there's data from someone who has requested to be forgotten, but it also satisfies legal hold. How do you resolve that conflict? Is there a clear winner, clear loser? Is it an it depends kind of situation? And when I brought the topic up first to David and said, is this real? Am I the only one asking this question? He sort of laughed and said, no, this is, the hottest topic of the day. And in fact, while we were waiting to log on just a moment ago, it's shown up on 60 Minutes and on the news. It's all over the world. So I'm hoping that David and Denise will set you all straight as they've started to set me straight on these issues. All right. So David, Denise, everybody on all sides are really kind of unclear on how to approach these what seem like conflicting requirements. Can we start with what are the obligations of legal hold? What are the obligations of GDPR? Can't we just opt out?
Well, yeah, would that it were that easy. We wouldn't be having this chat. So let me start with legal holds in the U.S. Legal holds in the U.S. got their invitation to prime time in, I guess, 1994, 95, in the Zuba era, when we started looking at legal holds as an obligation that was a necessary predicate to the fair administration and the just resolution of cases and controversies that were before the court. And the federal rules of civil procedure, which came into play in 1938, wanted to level the playing field. They wanted to get discovery out and get the facts and the evidence on the table and allow people to make decisions based on that, based on the evidence. So preserving the evidence that was interesting or relevant to the case or controversy was an obligation for a long time, making sure that that obligation was adequately communicated with specificity under attorney oversight, periodically reminded, methods and processes in place to test the sufficiency of your preservation obligations, and taking those obligations seriously as a matter of policy, governance, culture, really has evolved to a fairly high standard in the U.S. And is taken in civil litigation to be de rigueur. It is the floor, not the ceiling, of where your obligations start. And understanding that preservation is tied to claims and defenses, and that it's informed by proportionality, are sort of the touchstones of where we find the U.S. legal hold obligation resting. Denise?
So when you reasonably anticipate litigation, you have a duty to engage in a reasonable process to identify and freeze data that might be responsive in the anticipated legal action. And in order to do that, you need to inquire about the IT systems, identify who might have data that's relevant to the controversy, the dispute among the parties. And one of the things that are characteristic of the U.S. and other common law systems that's not familiar in civil law systems is that we have self-executing discovery. So this is something that the parties engage in. The court only gets involved if there's a problem. So the parties have a duty to disclose information and exchange information, and they only involve the court if there is a problem.
So let me just ask the obvious question. I'm listening to this webinar from the EU. I'm in France. I do business in France. Do I have any U.S. legal hold obligations, or can I just opt out of that?
That's going to be a complex question, and it will be driven by many things. Having selected France, we've got more than the GDPR to worry about, and that's going to be true in any particular country that you pick. There are going to be local laws, national laws, in addition to union level laws or other federal laws that will come into effect. But on terms of the whether there's an obligation in the U.S., the data or the information that you need to identify for the legal hold needs to be within your possession, custody, or control as a party. Exactly how that gets interpreted varies quite a lot through the different circuits and jurisdictions in the United States. So there's no straight answer to that. But when you're analyzing this, you need to look at corporate structure, agreements among entities. Depending on the jurisdiction, if you have a practical ability to obtain the data in the usual course of business, the court may find, yes, you have an obligation to get that data under control for litigation purposes.
And then there's the question of whether in France, putting the information on legal hold constitutes processing the data for a purpose that may or may not have been disclosed to the data subject. So you layer in France, in Germany, in countries with highly evolved privacy regimes, you layer the question you just asked with, as Denise said, both the culture, the national laws, and then this GDPR overview. In some ways, it may be more useful to folks on the call to focus a little more on GDPR and a little less on the country-specific idiosyncrasies, because you're always going to have to deal with GDPR if you're talking about the member states or the European Economic Area. You're not always going to be talking about French law, obviously, if you're dealing with the UK or Germany. So there you go. There's your first "it depends" answer from two lawyers.
Well, let's flip it the other way then, because I think a lot of the corporate listeners on this webinar today are based in the U.S. and let's say do business primarily in the U.S. How much do they have to worry about GDPR? Can they just opt out of GDPR?
So I think that's the question as you put it, can you opt out? a corporate entity is not going to be able to opt out of the GDPR. So the GDPR protects the rights of individuals, of so-called data subjects, in their personal data. And that will include corporate data. It will include classically the kinds of data that we need to preserve for litigation purposes, for example, email. If you have an IP address, if you have anything that allows an individual to be identified specifically, that's going to be personal data potentially subject to the GDPR, and that needs to be taken into consideration. So the company is not in a position to waive other people's rights. It may have a different way to thread the needle, but it can't opt out.
Yeah, and that's a question that I get asked, I would say at least once a month, by attorneys in corporations that say, maybe we're just going to opt out of this. And for a time, in May and June of last year, when the GDPR came into this year, I should say, when the GDPR came into play, I was in Europe and was trying to access certain websites. I think Crate and Barrel or West Elm. I mean, literally, I was just shopping. And the sites were blocked because the U.S. retailer was not allowing the collection of personal data from a member state at that point in time, presumably because they weren't ready to handle that data in a compliant manner. So I thought it was interesting that there was that wall put up, and that is a way to opt out, is to not take in subject data that is subject to the GDPR. But otherwise, it's a law of general application.
One thing that came up in our preparation for this webinar is that sort of third bullet down there, which I think a lot of Americans don't really appreciate, is that data privacy is seen as a fundamental human right in Europe, similar to what we would consider freedom of speech in the United States. And so it's not a question of opt in or opt out. It's a fundamental human right.
That's exactly right, and I think that's exactly what the GDPR is trying to address. There were previous provisions in place that were perhaps not taken as seriously as they needed to be. So the GDPR has really amped this up and made it a lot harder to just do an end run around that right. You now have to have in place a compliance mechanism so that when you're engaging in data processing, you need to take this into account. You need to be aware of the personal data that's within your organization and take appropriate measures to monitor what you're doing with it, record what you're doing with it, and make mindful decisions about whether you should collect it and how you're going to keep it, what kind of notice requirements are in place, how you're going to protect it, how you're going to dispose of it. All of those things are now part of the GDPR. There's a mindful process around managing personal information.
And to Denise's point, this isn't new. The GDPR is new. The imposition of a single regulation as opposed to a directive implemented by the member states, that is new. Previously, though, for the last almost 20 years, we've had a privacy regime in place. The GDPR is, as we say, amped up a bit. But to the fundamental rights question, the U.S. Bill of Rights is the first 10 amendments to the Constitution, and those are things that Americans take very, very seriously. And we have a good deal of our constitutional jurisprudence in the U.S. is around those rights. Think of it the same way in Europe. You wouldn't be cavalier about trampling on the Bill of Rights. In like fashion, the Europeans are standing up and saying, you can't be cavalier about trampling on our data privacy rights. We are seeing the consequences of those rights being infringed, and we're not having it.
So do we have any privacy protections in place in the U.S.? Is it just a cowboy free-for-all here?
Well, we actually have a lot of data and privacy protections in the U.S. There is no one overarching scheme comparable to the GDPR, but we have industry-based sectoral protections. The financial industry, the healthcare industry are obvious poster children for that. In addition, there are cyber laws, there are state laws, there are many, many layers of laws, but they're not consistent across the country. It really is a patchwork. And so understanding which laws might apply is complex and very much dependent on the organization and what kind of data you're talking about.
Okay, so we've brought up GDPR quite a bit, and we'd like to ask you this poll question about GDPR, which is how close your organization is to full compliance with GDPR. This is something that we ask on our webinars from time to time. The last time we asked it was in April this year, before the GDPR officially took effect in May. And so we're going to compare your answers now with answers in April. If some of you were on that earlier call, that'll be interesting. But just as the sort of joint Epic Valora audience, just to see how we have matured, or if we have matured in that time frame. So everybody go ahead and put your vote in for how far along you are in compliance with the GDPR. It's a big, I can already see it's a big difference from April. It's excellent. All right, the votes are all coming in. We'll leave it open a couple more seconds. Most of you have voted. All right. Here's how we're doing. Looks pretty good. The majority of you feel that you have this under control. That is fantastic. And maybe now that's why you're looking at these other issues of, okay, I've got GDPR on my left hand and I've got legal hold on my right hand. You know, now that I'm comfortable in both worlds, how do I make them mesh? Just for everybody's comparison, so take a good look at this because it's going to come off when I change the slide. This is what that looked like in April. So a little bit different. There was about 60% said we got this now compared to about 40% a few months ago. So there's definitely been a change. And there was a big change from those who said, well, you know, we kind of sort of have some data policies in place. That number's way down from about 30% down to about 13%. So the majority of those folks really kind of got more sophisticated, more under control in the last 6 months or so. So that's a very good sign. All right, let's move on to the actual conflicts. When and how do these conflicts... go ahead.
Just one point, Sandy. I was just reading this morning and talking with Denise about an IAPP and Ernst & Young study that came out, and I think that may help inform some of this trending that we're seeing. In the run-up to GDPR, it's estimated by E&Y that the Fortune 500 spent a little over $8 billion in GDPR preparedness in the U.S., and that number is a significant amount of money to have invested in this. But the overarching sentiment was that until and unless there are responsibilities landed at the feet of individuals in the organization, that is to say, like Sarbanes-Oxley lays liability at the board's feet, until GDPR does the same, we won't see the massive investment needed in sort of the next tier of corporations in the US to become compliant, but that is probably the driver, and that like HIPAA, like Sarbanes-Oxley, until enforcement actions became personal, progress wasn't really sincerely invested in.
Very interesting. Okay, so let's get into some of these conflicts, where they start, how they happen, which ones are a little bit more reactive in nature, and which ones are necessarily proactive in nature. So for example, maybe David, take us through what it means, you know, why legal hold is sort of the official start of activity. What do we mean by that?
Well, because legal holds are triggered, the triggering event can be pre-suit. It is an earlier start than most people would think in the context, certainly, of a civil law country, that there would be discovery obligations, that there would be evidentiary obligations before the court was involved. And in a self-executing discovery state, which is where we find ourselves in the US, that obligation attaches when you reasonably anticipate litigation, or when you reasonably anticipate a regulatory action, or some reason where evidence would need to be preserved. And companies engaged at the outset of the, I guess, OOs, the late 90s and the early 2000s, in what were called litigation readiness or litigation preparedness activities. And those activities sought to do things like create a data map and prep 30B6 witnesses, or at least to designate 30B6 witnesses for corporate witness testimony, to update policies, to develop legal hold programs, to perhaps buy technology to help automate, document, record the defensibility of your activities that could very well be pre-litigation and litigation never materialized, or pre-litigation and litigation materialized, or you got handed a summons and complaint. So there were lots of different times that you would engage in this, but there was this idea that if we know what we have and where it is, we'll be better able to preserve it. And then smart people said, if we know what we have and where it is, shouldn't we know why we have it and for how long we're keeping it? Because discovery is expensive. What if we engaged in perfectly permissible data minimization activities, defensible disposition projects, started to be coextensive with litigation readiness, so that the corpus of information was better understood. I bet Denise is going to talk about something very similar in the next breath, because knowing what you have, why you have it, and where it is not only important to litigation readiness.
Right. So under the GDPR, as we've said, there's a need to understand what kind of processing you're engaging in for personal data. Both of those are very broadly defined. Pretty much anything that you do with data can be defined as processing, and the scope of identifiable information is very, very broad. So as an organization under the GDPR, you need to analyze what personal data processing you're engaging in, identify particular risks that are associated with that, determine whether the processing is appropriate and how you're going to manage the data around that. And that's to be done in accordance with the data processing principles that are outlined in the GDPR. These are familiar from the old directive. There's a new emphasis on transparency, but basically your processing has to be fair, lawful, and transparent. And the GDPR has a compliance mechanism around ensuring that kind of activity is being done appropriately and in a defensible and recorded, mindful manner. And if we're talking about conflicts, those are two very different approaches. From the US side, the key to legal hold is being able to suspend your reasonable data disposition process as soon as you reasonably anticipate litigation. That's not something that's generally going to be a consideration for European side. If you've decided that you're going to anonymize data or pseudonymize data, that's the kind of conflict we're seeing. Sandy, you mentioned earlier a potential conflict between erasure or the right to correct data or to do something with the data that would not be conforming with a legal hold process. So those are the kinds of potential conflicts that can arise, and having a process in place to address those as part of the making those two systems converge.
I agree. I think one of the fundamental tenets that I take away from GDPR that is in tension with my U.S. training as a lawyer engaged in litigation activities is data minimization for the GDPR purposes, to retain only so much personal data for only so long as is necessary for the purpose for which it was acquired, and then documenting its life cycle, its end. That to me is anathema to someone who is putting together a litigation hold program where I will have the ability and the technical means to put a box and a fence around stuff and hold it so that I can, defend a claim or assert a defense.
And I think this is a very important point here. The GDPR is about facilitating the appropriate flow of data to support commercial and other important ends within, a defined safe area. It is not about U.S. litigation. So all of these provisions, we are constantly having to look through this from this litigation, legal hold perspective and see how can we make that apply? What kind of sense can we make of both systems so that they're trying to resolve these kinds of conflicts, how we can come up with a reasonable approach that's going to maximize compliance on both sides.
And as the sort of the technologist in the equation here, I will put out that given that there are conflicts and reasons to kind of reassess data or reassess your policy or your position given various conflicts, that you pretty much have to have some sort of tool or technique for being able to understand, terabytes, petabytes of content in a relatively easy and painless manner, because you can't even have a reasoned discussion. You can't even have a trade-off between, penalties or likelihoods if you don't even know what you have. So I know the information governance folks on the phone are cheering right now, but the technology is available so that the conversation should revolve around the conflicts and the resolution and not around, well, what do we have anyway? Does this even apply to us? That should be a given, and technology kind of solves that problem right at the get-go. All right, let's move ahead into some considerations around these issues. Some people, especially here in the US, think that GDPR was the start and birth of data privacy regulation, which is, of course, absurd. This has been going on in many ways for a long time, even in the United States in little pockets. David, take us through a little bit some of the lessons that have already been learned from data privacy regulation.
So we alluded earlier to the 95 directive. That was the prior privacy regime, and it was legislatively enacted as a directive to the member states to implement privacy consistent with those standards in the directive as the floor, not the ceiling, of the national privacy law in each of the member states. So your data privacy law in France, in Germany, in the UK, go on with all the member states, were the same but different. So they had a core floor set of principles. And I have to say, the principles in the GDPR are not so radically different. The concepts espoused by the EDPB, the European Data Protection Board, which is the successor entity to Working Party 29, which was the directives collective voice. They're very similar. The WP 29 group and the EDPB are singing from the same hymnal. The directive and the GDPR are not so radically different. What's radically different is, as Denise said, is the consistency and the ability for the regulators to enforce compliance at a European level. So big not big changes in the content, in the subject of data privacy, big changes in enforcement, big changes in consistency. The U.S. has had its struggles with the directive for a long time. U.S. courts are of the opinion, largely, that the U.S. laws and the U.S. interests in administering justice in the U.S. for U.S. cases and controversies is really what's important, and the rest of it, not so much. We need this discovery to resolve this case, and we want to do it in a FRCP Rule 1, just, speedy, and efficient manner. And getting European data privacy involved in the mix just delays, increases costs, and can frustrate the administration of justice in the U.S. So, not a great deal of initial respect was accorded the law. That moved into Supreme Court jurisprudence in the Aerospatiale case, where a comity analysis was developed to see if due respect to the law should be had. And I will say that in many, if not most cases, the U.S. came down on the side of U.S. interests over European privacy law interests. So the idea here is that the Europeans are going to take this into their own hands and provide a heavy enough hammer to get the attention of the data processors and controllers, as opposed to persuading the hearts and minds of the U.S. judiciary. Is that somewhat fair, Denise?
I think that's entirely fair. I think one thing that we are seeing in the case law that's developing in the U.S. is with a change in the federal rules a few years ago, the concept of proportionality is somewhat in play when you're looking at extra U.S. data. So we have a few decisions that have given more weight to the basic principles of proportionality, the cost, the burden, relevance, without actually engaging in that full-blown comity analysis and making it in a U.S. versus the EU. And where there has been a full comity analysis, there's an increasing body of law that's trending towards understanding that the laws are not necessarily being put forward for a bad purpose, that people are trying to delay discovery.
And we listed some common pitfalls here, which of course are the usual litany of pitfalls. Why does this happen, or where does it come from? Why are organizations on all sides falling into common pitfalls?
Well, I think that there is uncertainty. I think that is the hallmark of where we are right now with the GDPR. The law is broadly written, and guidance is emerging as to the EDPB's approach. Sorry, it's a new acronym, and I'm still learning to roll it off my tongue. Guidance is trickling out, and that's to be expected. But it's frustrating for organizations. In fact, this week saw developments over the last few months that are significant and impactful.
So this week we got some guidance on the extraterritorial scope of the GDPR. I think we're all still digesting it, but basically the tone is extremely practical. It's based on examples. I don't think there were many surprises there. The EDPB has embraced the existing guidance on some of the issues. It's very, very fact specific, but there are a series of examples that are really helpful in working out how things will move with this particular combination of chess pieces on the board. Earlier, actually on May the 25th, along with the GDPR itself, we received some guidance on the derogations under Article 49 of the GDPR. And so basically, one of the issues is cross-border transfer. We haven't talked about that yet, but we've talked about processing and limits on how you process personal data. A special form of processing is cross-border transfer. If you're taking data outside of certain approved locations, you need to have additional considerations about how you're going to do that, what the bases are. And we got some very helpful guidance from the EDPB outlining a layered approach. If you're taking data outside of the EU, there is a series of measures that might be in place that you can see if they're going to be appropriate. Most of those are geared towards transactional data movement. So for litigation, it became problematic, and we didn't have very clear guidance before. Now we do. There is a derogation under Article 49 that allows for the transfer outside of one of these approved areas of data for the defense or assertion of a legal claim. Now, we have to be very, very careful about this. There's a tendency in the US to look for, there must be a way around this. And Article 49 does not stand on its own. It's very, very clear from the guidance that this is not an end run around data protection. You still have to abide by the earlier articles that outline all the principles. You have to abide by the data minimization, the transparency, all of the things that we've talked about. There are the notice requirements, all the other requirements. So the data protection measures are still there, but you do now potentially have a basis to take the data outside of one of the approved areas for a legal claim.
One thing I will point out to folks here, again, a very American kind of point of view, which is for data that is in the cloud, there's a thinking of, oh, it's in the cloud, so it's sort of beyond jurisdiction, as if the data was really being stored in the heavens. That is not true. We say the cloud, but all cloud data is actually being hosted in a facility in some country or other. And so I just want to kind of remind people that you are not immune to this just because you have data, quote unquote, in the cloud. It's in the cloud where? And you will find your cloud providers have their cloud locations are identified by country, and that's why. We kind of touched on this last bullet already, but it's certainly worth reiterating, so I will, which is that historically separate groups, maybe under the legal banner corporately, but folks in litigation are kind of often, off in their own universe focused on litigation, and folks worrying about data privacy or security or compliance tend to be in another. You now have a shared goal in getting your arms around that enterprise information and understanding and knowing what it is. So the good news is that you get kind of double, triple, quadruple bang for the buck around something that everyone's always wanted to do, but from time to time it was hard to justify purchasing equipment, purchasing software, taking the time and effort away from other activities just to be able to analyze our content. Now you have common friends and common budgets to be able to do that. So this is a kind of glorious moment, if you will, for accomplishing a task that's been on the minds of information governance professionals for years.
Sandra, I think that's true for organizations that are recognizing that. I think from my perspective, a lot of companies begin to see that really when litigation hits. They may have their GDPR process in place and they may have had their litigation process in place, but it's when there's new litigation that those two things are coming together. But other organizations, certainly they've had their stakeholders identified and at the table and discussing these things in advance.
Mm-hmm. All right, it's time for our last poll of the day, where, again, this one's going to compare today in the end of November with the last time we did this poll in April, just to see how things have changed. And we're going to be asking you specifically which GDPR issues most concern you. And we'll see if that has changed over time or not. So please put your votes in for, I realize you can only vote for one, so pick your most critical GDPR issue. If people are unfamiliar with the DSAR acronym, that's a data subject access request. It means employees or clients or suppliers asking for specifically, what data do you have on me? So we'll give that one a couple minutes for people to vote. I like these polls. They wake everybody back up. All right, the votes are coming in now. Almost all of you have voted. We have a nice range of concerns here. All right, let's see. I'll share with you. So here's what we have, a nice spread across the concerns. And that actually is similar to, but different, like high flyers compared to when we asked this in April. So it's by a slim margin. It looks like at the moment, proper data storage and access is kind of beating out the second choice, which is responding to DSARs. That's a little bit different than what we saw in April, particularly the DSARs. And I think that's because the regulations are now in force, and so the DSARs are rolling in. I'm sure they are. So I'm going to now hide this and show you what, so get a good look, and what it looked like in April of this year. So you can see people were not so concerned about processing requests because it hadn't really hit yet, and now they have. And coordinating was the big concern then, and much, much smaller concern now. David, Denise, I don't know if you have anything to add here.
I'm certainly seeing a concern about responding to the data subject access requests. There are time limits around those, and in the scope of them, scoping those out has been quite challenging.
We're seeing an uptick in people who are asking us to help repurpose discovery tools for responding to DSARs, and whether we can use our review facilities to screen the materials and get them ready to go out the door. So I mean, those are typically things we do in the e-discovery side of the house at Epic, but we're being asked to think about those or rethink those in light of DSARs, particularly in our European offices.
And one interesting note about that is that you're seeing other laws in different countries that feed into some of these issues. So, for example, in the UK, you can see new laws with penalties for altering data after it's been sought. So that there are other considerations in play here, as this is a very much an evolving landscape.
Okay, so let's get into the takeaways now. If we're not actually going to kill each other over these things and we're going to try and resolve conflicts, how do we work with one another? How do we work within our own organizations to make things smoother?
Well, I think that planning is a big part of it. I think understanding your risk tolerance and understanding your litigation stance. There are some organizations that have traditionally taken a scorched earth policy that are going to take every single thing to the mat. They're going to litigate. And in resolving conflict between separate sovereigns, legal structures, that is going to be an expensive uphill battle that may not yield a result that you're terribly happy with at the end of the day. And it may put you in a position that you wish you weren't. That is to say, being ordered to violate the law of a separate sovereign in order to comply with the law of a court. So I think that there's definitely some strategic thinking that has to inform the corporate approach before we get to these very specific tasks. Denise?
As a litigator, I mean, having this in mind, looking for these issues early, being aware that with the globalization of the workforce, with modern data storage practices and data management practices, there's a good chance you're going to have data outside the US that may be called for in a US litigation. So this just needs to be part of your analysis and part of your planning as a litigator or as somebody responding to government requests or assisting with internal investigations. Just be aware that there are going to be these issues as you go outside of any particular jurisdiction.
And Denise, should we leave this to the very last minute at the 11th hour when discovery is closing?
It's not uncommon for that to happen. Two things on that. A, the answer is no, but B, making promises early on and then not being able to live up to them has got a number of parties in trouble. So if you've gone into court and said, sure, you can have the data from Macau or wherever it is, and then you can't deliver, that's going to be a problem for you. You're going to lose credibility with the judge. If you're going to face these cross-border issues, you need to anticipate and educating not only your opponent, but the court. They may not have seen these before. There may be truly limited understanding about what's involved and what the concerns and issues are. So having the ability to educate the court, the parties, and to have a good plan. You can't just go in and say no, but you need to say this is what we can do and here's how we're going to go about it. Make sure you have a positive offer, the alternative no. These are the things that we can do, and then eventually we'll get to the trickier stuff down the road. So those kinds of things would include phasing discovery, first focusing on available data, the US data sources, looking for non-personal data sources that might be sufficient for the purpose, taking measures to preserve, which can be problematic under the GDPR, but doing so on a basis where you're trying to minimize the data, having a reasonable approach to things, making records of it, giving the appropriate notices, so that everybody is aware of what you're dealing with in Europe. Also setting realistic expectations about how long this is going to take. If you're going to need to engage in privacy and other review in Europe, if you're going to need to engage in data analysis, you might need to arrange for the technology to be in place if it's not already there. Those things take time, and you need to be realistic about that with the court and your opponent.
Recourse to the Hague Convention can add delay and expense.
Yeah, that's an interesting development. Typically, courts, the law in the United States is that the Hague Convention on the discovery in civil matters of evidence abroad, that the U.S. Supreme Court position is that that's not required, and it's not even there by default. But under the comity analysis we discussed earlier, it may or may not be available or appropriate to do that. We do have one recent case where a court allowed discovery to proceed actually under the Hague Convention, Chapter 2, where you have a sort of a private arrangement in place. The case settled before that really played out, but it's again, you're seeing some receptivity, some sort of resetting of expectations in the United States. There's increasingly some precedent you can draw on to show that courts are, facilitating compliance with foreign laws where there's a problem.
I think another key point is one that Denise alluded to earlier, which is the proportionality in the discovery arena now as a front and center piece of the federal rules. Pushing back against discovery requests that are overbroad and saying they're overbroad, not terribly helpful. But being able to, with specificity, tailor your objections to discovery, confining them to claims and defenses, looking at the cumulative nature of the information that may be abroad, looking at whether the data needs to be connected to a identified or identifiable person. So anonymization or pseudonymization, can you say it?
Pseudonymization.
Thank you. Of the information can be negotiated, agreed to by the parties, and presented to the court. The use of protective orders should be considered. But saying yes, you can have it all, and yes, we're going to get this for you, is likely to be problematic. And then you're going to be doing this risk analysis of where do I want to fall, on which side of the trouble.
So we are coming to the last 5 minutes of the webinar. And so Denise, David, I'd like to ask both of you if there's only one thing people took away from the webinar today. Each of you tell us what you hope that is.
For me, it has to be planning, just anticipating that this is going to be an issue, and having tools available to deal with it. David, I probably took your thunder. I think everyone's going to say, if you talk to the people on this side of the microphone, would all say it's about anticipation and planning.
Well, I also think it's about education. I think you have to educate yourself as to where your data is, and ideally engage in a thoughtful analysis of why you have it where it is, and why you're keeping it, so that you can make better choices about discovery, about GDPR, about good data hygiene, about respecting fundamental rights of data subjects, consistent with the law.
And we have quite a lot of resources that David and Denise pulled together for you all. They're all here. Everybody on the webinar today will get a copy of this presentation, and the links are live. So you'll be able to go educate yourself, as David just advised, on lots of different areas related to this. And there's more coming out every minute. So stay current, and of course, feel free to contact any one of us. We are happy to talk about this probably forever. And so here's how to reach each of the three of us. We very much appreciate everybody's attendance today. If you have a quick question and you want to pop one off, by all means, please do. We'll be around here for a minute or so. We already have a thank you come in, so you're very welcome. And we very much appreciate everyone's time today. Thank you very much. And thank you, Denise and David, for participating. Your expertise is unmatched. So thank you.
Thank you. A pleasure.
Thanks.